do I have Elazar Jackson? Right, be just a minute here. So if I understand correctly, Annette Jackson, you are present, is that correct?
That's correct, Your Honor.
All right, so Ms. Jackson, what I wanted is to set this over to March 26th at 9 to have a response from you regarding the medical.
I haven't gotten nothing from him.
Okay, well, that's an issue. I'll recall this in hopes that he will join, but he should be submitting everything he files with the court, a copy to you.
Yeah, I have not received anything.
Okay. All right. Now, let's see if he joins after a bit. And like I said, I'll recall. Okay.
Okay, so the motion, because with him being in contempt, is not gonna get heard at this point.
I don't even have him here.
Okay,
So that's a real problem.
okay,
And it's a real problem that he's not submitting to you the things that he's filed with the court. So we need to just wait a little longer and
all right. Thank you, Your Honor.
all right, so a couple of things that need to happen. First, Mr. Jackson, you need to understand anything you file with the court, a copy of it needs to be provided to Annette Jackson.
I did provide a copy.
Okay, she's saying she hasn't received anything.
But the address that's listed on the paper she served me.
Okay. Do you have the item scanned by chance? Scanned into a PDF document by chance?
Do I have it scanned in
Uh-huh,
personally? No.
okay. All right. Ms. Jackson, anything that you've received at all?
No, because he's supposed to email it to me. And I received nothing by email.
Okay. Well, did he mail it to you?
Well, I'm homeless, I don't have an address.
Okay.
So that's why I put the email on it. On the paperwork, the second time, even when I had to serve him, that it says to be delivered by email.
Okay, well, there's no court rule that says it must be done by email. Just
Okay.
because you want it by email doesn't mean that it needs to be done by email.
Okay.
Unless there's agreement, and that there's no agreement. So he's filed documents that haven't been scanned, and that's the problem. And at least you can do a general delivery at the post office, at least you used to.
I mean, he sees our daughter on a regular basis. He used to give it to her.
Is there an address for
Yeah.
him to mail that to?
Yeah, she has an address, but he can give it he sees her personally, so he can give it to her personally, and she can give it to me. We had made an agreement prior to send everything by email to me. I mean, he sees our daughter at least once or twice a month.
Mr. Jackson, would that be workable if you provide a copy of the documents to the daughter?
Unfortunately, I don't have my daughter's address. She moved and has not given me an address. I saw her once in the last 3 months.
That's a lie.
Okay, stop. I am not going to put up with this. So we're going to get this done. I have a whole docket I have to do. So here's what's going to happen. All right, you're going to provide the address to Mr. Jackson of where you want things sent. If that's the address you want things mailed to, you need to also change it with the clerk's office. Okay. And then that will be your official address for where things are mailed to, because sometimes the court mails things too. I understand what you're saying and why you're saying it and the allegations. I've read things. So I need you to make a copy of everything that you have filed with the court. And once you get that address from her where it's to be sent, then I want you to send that to that address.
Yes, ma'am.
Okay. All right. And then I'm going to set this out 2 weeks to have that happen. All right. So get that address to him right away and to the clerk's office right away. And that way things can be sent to that address, okay? But you have to have an official address.
The clerk, I had changed it a few weeks ago. The clerk, at the clerk's counter, I changed the address to my daughter's address, so it is in the court system.
Okay, but then you also need to provide that to him, okay? Same thing, everything you file, everything you do with the court, you need to let the other party know, goes
Okay.
both ways. Okay, so I'm setting your case over 2 weeks. And then that'll also give you an opportunity to respond to the medical matters that were brought up,
Okay,
okay? Okay,
all
so
right,
I'm not doing anything further today,
all right, thank you, Your Honor.
okay? All right,
Thank you.
that's the Flick the Bondurant matter.
That matter's ready.
It'll be just a minute. Okay, we have Miss Bliss. Do we have Isaac Bondurant present?
Yes, Your Honor.
Okay, thank you. And do we have Heather, is it Call? Is that how you say your last name?
It's Kale. Thank you, Your
Yeah,
Honor. Good morning.
okay. All right, so I did not see a guardian ad litem report. So can you tell me the status of that?
Absolutely, Your Honor. So the report's actually almost finished. My intention was to file.
You muted. You muted.
Actually had his substance abuse evaluation as it was ordered by the court. However, it had not been filed with the court or provided to me or Ms. Bliss. And I recognized in the parenting plan that had that been filed, because it does not recommend treatment for him, he could have been having supervised visitation with the kids. And so I encouraged him to make sure that that got done. We also realized that Ms. Flick was not able to give the collateral input that was required by the court. And as I understand it, Mr. Bondurant went down today or called the facility today and asked them to reach out to Ms. Flick so that she could give that input. With all of that, and I also have not, the mental health professional that the girls have been working with has not returned my outreach yet. And I feel like until I have that output and I get a little more information from the substance abuse evaluation, as well as maybe a visitation or two from Mr. Bondurant, I'd like to extend the deadline so that I can get that information before we file.
Ms. Bliss?
And Your Honor, most of Ms. Kale's statements to the court this morning were brought to my attention yesterday. I also was unaware that Mr. Bondurant completed his evaluation. My client did not provide any collateral input. She was not contacted. So that obviously needs to be remedied. I agree that Ms. Kale should probably have that information, have some information. If visits do resume, the girls are simply having phone calls with Mr. Bondurant at this point. So I think in order to get the clearest picture for a final GAL report, I think it's beneficial to extend the deadline.
Ms. Bondurant? Anything?
Yes, I agree. I would just, if at all possible, as soon as we could get a court date at the earliest, that's all I'd ask.
Okay, well, this is a lot depending on you and well, I guess you did your evaluation. So now it's a matter of getting the input that was supposed to happen. So with that, Ms. Kale, what are you thinking as far as how long it'll take you?
I was hoping that we could have our next court date. I mean, if he can get that collateral input taken care of, and we can get a visit or two, his visitation supervisor is going to be Beth Fellows, who I think is a really important asset to this information. So if we can get a visit in and some collateral input from Ms. Flick for that evaluation, I can file this report, and actually we could have a court date on April 23rd, if that works for everybody.
Ms. Bliss?
That works for my calendar, Judge.
Mr. Bondurant?
That's fine, Your Honor.
Okay, so do you know who
Billy,
you need to contact? Hold on. You know who you need to contact for visitation?
Yes, ma'am.
Okay, so go ahead and get that contact made so you can have your visitation, okay?
Okay, can I say one more thing, please?
Go ahead.
So when I called the Family Health Center about my SUD, they just allowed me to know I just need to go down and fill out an ROI, and then Taylor can call them, but they don't call people or reach out. She'll have to reach out to them after I've filled out the ROI.
Okay, so I want you to do
Which I'll
that
do.
today. And then Ms. Kell, you'll need to contact them today, as well as your client, Ms. Bliss.
Yes, Judge,
Yes.
and she's present on Zoom today, so she has that information now.
Okay.
And I would, if I could make the request, Your Honor, that Mr. Bondurant add me to the ROI as well, that would be really helpful.
You're already on it, Heather.
Excellent. Thank you.
All right, what date were you asking for? April?
23rd.
Okay. All right, so we'll go ahead and set another final review over to April 23 at 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Mr. Sandy present
Thank
here
you,
in
Your
the
Honor.
courtroom. Do I have Christopher Myers?
Your Honor, Grant Brewer here on behalf of Mr. Myers.
Okay,
And I'm requesting a continuance on this to April 9th. And opposing is objecting, so I'll give you my pitch when you're ready.
go ahead.
Well, we already had temporary orders resolved or decided basically in December. So that was done by the court, and then council filed this in February. Our view is it's kind of a redo or a re-ask because they're asking for more money. But the point is, I notified council at the time that I was going to be out of the office for 2 weeks, including the date he set for hearing. We discussed, and my client paid 2 months payments on the motorhome to get us past that date. I let him know I would not be available likely for this hearing because having returned to the office, I wouldn't have time. So I asked him to set it out further. I haven't had a chance. My client lives out of state. I have not had a chance to file responsive documents. I don't think there's prejudice given the payments that have been made. So I'm asking for the 9th to give us time to file a response. It's a pretty simple motion, and I don't think it's going to take much once I can get in touch with my client.
Counsel?
And Judge, this has been pending since early February. I think we filed the motion back on February 5th. We had initially set this for February 27th. Mr. Brewer did contact my office, speak with me about a set over. We agreed to that, and I know that he had scheduling issues, was out on vacation. His problem with his client is that he hasn't been real responsive throughout the course of this, and that's been an issue for my client. We've made that pitch back in the fall during temporary orders. Nonetheless, we agreed to set this over to give 3 weeks to file a response. I would agree with counsel. This is a very simple motion. This has been an issue that has been ongoing for some time now. We set it to today's date with anticipation that we could have a response. He's had now nearly over a month and a half to prepare that, and we're none the better for it. As far as it pertains to a settler, normally I'm very agreeable to that. I understand everybody has timing issues and independent schedules that they abide by. I get that. Try to be somewhat generous with that. But again, this is one that's already been set over. As council's words, this is a rather simple motion. Now, this is an ongoing issue. And my client, again, who's always taken pride in her credit's being destroyed because RV payment's not getting made. Now, Mr. has access to the funds. Mr. has the majority of income in this case, and it's basically just choosing to sweep this under the rug in hopes that it goes away. We need this addressed. We're asking that goes forward today. Also, part of this motion is taxes. We're asking for the joint return for 2023. And again, if we bump this well into April, and that leads to the down the lines of extensions and the like, and we need to get that issue resolved. So we're asking to move forward today. I will certainly allow Mr. Brewer ample leeway in his response as he deems fit. But again, we need some resolution to this.
Mr. Brewer?
Well, I mean, I can testify on behalf of my client. That's not all I could do today. I think it's appropriate for give him time to file his response to the allegations. I don't agree with the assertion that he's not been responsive. In fact, he's paid when he hasn't had to, and I think that's important for the court to know, not to mention the status of what Ms. Myers has done in this matter in relation to not doing anything on the motorhome. I think that's all important information the court knows to make decisions. I'll also note we have settlement conference in June, just for the court's edification.
So my issue here is that this was already set over once. This has been pending for quite some time, and to ask for another continuance, I'll go ahead and grant a 1-week continuance. That's it. And I expect a response. So anything further for today?
Just fees for being here. Again, this is frustrating my client. She does not have the funds to continue to do this. So we are asking for contribution fees. Alternatively, reserve that until next week. I'll make that part of my arm.
I would just ask you to make it next week.
Very well. Thank you.
And then, Judge, is there a date certain? I know you.
Oh, that's to the 26th.
Yeah, my
9
response. Did you have a response date for me? I can have it by tomorrow, Judge, assuming I get a signature from my client.
That's fine.
Okay,
You can do it by tomorrow. Do I have
Okay,
Mr.
very good. Thank you.
Braglio present?
Present, Your Honor.
Okay. So, I'm going to address one matter here first. And that is Mr. Braglio has requested an attorney for the contempt, because it was understood that jail time was being requested. He has a right to an attorney. And it appears, at least from his statement, that he qualifies. So on the contempt matter, anyhow, we won't be addressing that today.
That's fine.
So Mr. Braglio, in regard to the appointment of the attorney on the contempt matter, that'll be done and you'll be contacted as to who that is. I don't know. We have to, staff has to search for who that is, or we'll
Okay.
take it.
Thank you.
So let's go to the other two matters. I want to first address the objection to the use of the content of the journal of the minor child. Anything further on that?
I think my client has detailed that in her reply adequately.
Any response on that particular issue?
My biggest concern, Your Honor, is that the material really expresses that she is being silenced by Ms. Buaglio and is scared to speak up. So with all the claims that she is making, I've tried to provide ample proof to what I believe are unsubstantiated claims. So that being used for evidence, I just think it clearly proves that it's actually contrary to everything Ms. Buaglio has claimed thus far.
So under the rules of evidence, it is considered hearsay and will not be considered by the court. All right, so let's go to adequate cause. Both of you filed motions for adequate cause, Mr. Sandy.
And that's where some confusion we did. I think adequate cause is quite clear, given the circumstances. I think there is certainly a change in circumstance. Again, I think that's detailed in both parties' declarations. We have very significant concern for that. Initially, it appeared in the first batch of responsive pleadings for Mr. Buaglio that he was stipulating to that and wanted to proceed. Last week, after filing our reply, we received a new set of documentation and proposed orders and the like in response to the petition, which denies the claim for adequate cause. So I really don't know where that puts us. My intent today was to go forward and present my argument as initially planned, given the most recent information he provided.
So let me understand this. Are you stipulating that there is adequate cause?
I wasn't quite sure, since I'm not an attorney, obviously, and just beg the patience of the court a little bit. I'm not asking adequate cause on the grounds that was filed by Ms. Buaglio and Mr. Zandy. I have concerns. The evidence that I was trying to provide is showing that it's crossing the line of abuse that I'm actually worried about from in the home of Ms. Buaglio, and that's the evidence I was trying to provide. And I still have hundreds of more pages to that effect. I've just provided a small sampling of my concern. So I do, to my understanding, it seems like I need to file my own paperwork to show that. My concern is if the adequate cause as presented today by Ms. Buaglio, Mr. Zandy is heard and followed through with, it would be extremely adverse to Adiel's safety and mental and emotional well-being if the parenting plan, the petition, is heard and moved forward with today.
So I think at this point, adequate cause to me is adequate cause. So I don't know if you see that any differently, Mr. Zandy?
I don't. I think you're right. I think once adequate cause is found, that opens the door for both parties to present to a GAL in the court. Again, at a future time, it's just opening the parenting plan parameters once again. So I don't think we need any separate filings. Of course, I'm not advising Mr. Buaglio of what he should or should not do. I think we can go forward today. I think adequate cause again is, initially I thought that was stipulated by everyone from its initial response. It wasn't until late last week when he filed basically a reply to our reply contrary, obviously, to the rules, that it became somewhat ambiguous as to what it was he was suggesting. So I think we can enter an adequate cause finding today, generically move forward on the temporary orders and proceed as such.
So work for you? It's just a generic finding of adequate cause.
The adequate cause would work for me, Your Honor. The moving forward with temporary parenting plan conditions as presented would be very harmful, and I do not agree with that at all. I actually think it's the contrary.
And we'll address that one
Okay.
As a separate matter, but this allows it to go forward.
I understand.
So I want to make sure you understand that.
Thank you.
Okay, so we'll go ahead and adequate cause generically will be found. So yeah, your order should include that. So let's go to the temporary order.
Okay, and thank Your Honor, sports aware, I do represent the petitioner, Jamie Buag, who's the moving party for the court today on our petition to modify the May 17th, 2022 parenting plan. There's two kids at issue. McKenna, who was 17, who is largely estranged from her father. There's been very minimal contact over the course of the past several years. And more importantly, for purposes of today, is the health and well-being of 13-year-old Abigail. I would say that the court is aware of the extensive history of this case. We were hopeful back in May of 2022, after a trial a couple weeks prior to that things would get back on course, that things would smooth out, that everybody would act in the best interests of the children, specifically Abigail at that time. And unfortunately, it took literally 3 days for orders to be violated or conditions to be compromised, again, by the same type of traditional history that Mr. Buag continues to engage in. Not only did it not get better, it arguably got much worse. We're now in the somewhat dire position of hoping that we can put this back together. Frankly, I have worked this case for several years. I'm not sure what else we can do. There was prior admonishments, there was prior sanctions, there's been contempt findings against Mr. Buag. There's been very strict orders, not just of Your Honor 3 years ago, but from Judge Fassett, who heard the hearing, from the GAL at the time, it was Mallory Smith, trying to put very clear safeguards in place to keep this child, keep both children, but more particularly Adiel, to keep her outside the scope of what we're doing today. And it just wasn't work. Nothing will resonate with her. My client has given you information in review of the pleadings filed by Mr. Buag. They're largely, they don't really dispute it. He says, well, essentially, I want the child to live with me. It's dangerous at Jamie's house without providing any kind of substantiating information related to that. And pretty much, again, just passes the buck down the road in order to try to take some of the focus off of his actions right now. They're atrocious. This child is suffering. We look at what specifically has happened. And again, we're going back to May 8th, which was 3 days after the trial, 3 days after everybody sat there on Zoom and heard Judge Fassett say, don't engage the child in any of this. Keep that out. You see the order. It's to be taken quite literal. Your Honor set that back in motion 3 or 4 years ago during temporary orders back then. The GAL confirmed that. And Mallory Smith a short time later. So these kids need to be kept out of this. Dad doesn't do it. What happens on May 8th? My client goes to pick up the child, and Dad, with his now current wife, walks out with Adiel, who at the time I believe was 11. Sits there and says along the lines of, go ahead and tell Adiel what the new plan is. It's what you wanted. That's not what I wanted. Go ahead and tell her that. Are you essentially happy with it? Which does what? Puts the child right back in the same type of nonsense and chaos that everybody tried to eliminate 3 days prior. Court has been very specific with him that is to not be tolerated. Thus the contempt. I'm not going to get into that, but everything dovetails into the same type of issues. So instantly this child is wrapped up back into this chaos. My client is detailed for you. She tries her best. She tries her best to eliminate that. That's coming at her burden at this point because Mr. Buag takes a completely opposite approach. My client, when asked and pressed by the child, and this is growing more and more volatile at this point. It's getting more persistent from this 13-year-old. Why is the plan this? Should the plan be that? Dad tells me so-and-so. My client says, this is what we agreed to. This is what the court set in motion. Everybody wants what's best for you. What does the child do? Well, that's not what Dad says. Dad already told him. Again, we have this resounding type of theme in which Dad is constantly engaging the child. The orders are very specific related to that. Moving forward, everybody realized children were to be in counseling throughout the process, again, to help them cope. recommended by the GAO. I thought everybody agreed to that, and that was certainly the order of the court. It's very clear in the parenting plan. What does dad do? Dad takes intentional steps to undermine. Child's been seeing Janice Schmutz, Northwest Site, has been seeing her for a long time. It's a good therapeutic relationship. Dad goes out of his way not only to not really engage, and he gives you some information that says, well, I reached out to the counselor on this day, but he's undermining the process. He's telling the child, hey, you know what? When you turn 13, you get to decide if you want to go or not. So just bide your time until you're 13, and then you can decide what you want to do. Undermining that process. It's the same individual who years ago sought out his own counselors for the child and said, you're going to go to this counselor, and we're not going to give any information on that. Again, subject to past contempt proceedings in court action. So the same individual who now is telling the child, and this, I've never seen this in nearly 18 years of practice, where the child goes through what's called a transition time before going to dad's. Current parenting plan, my client has custody. Dad has alternating weekends, Friday to Monday. For the first hour, and this is referenced in the text communications that we filed alongside this motion. For the first hour, the dad goes through what's called transition time. Transition time is where the child sits down, not just with him and his wife, but extended family members, and talks about her journal entries, the same ones that he tried to provide as evidence for today. They go through, which is basically a tattletale list of everything that happened at my client's home for the past week and a half. But a child then sits there and tells grandma and grandpa and dad and stepmom and everybody about everything that happened, and they sit there and critique the journal. Dad then tells her, okay, this is what you do at your mom's house. I'm going to give you 31 activities that you can do. And I'm basically going to dictate mom's time. Of these 31 activities, none of them are engaged with your mom, your sister, or anybody else. It's basically sequester yourself in your bedroom and just work on Bible study and work on, again, 30 other things that you need to do. Number one, I believe, is journaling. In which you're sitting there tattling on mom and your sister, and then we'll talk about it when we get you on Friday through this quote unquote transition time. This journaling is not private. This journaling is not for the well-being of the child or child. This is so dad can sit down with child and talk about everything that mom did. So again, he can brainwash this child and manipulate what my client details for you as a very sensitive 13-year-old who wants to please everybody, manipulate that child into thinking that he's some kind of a martyr. That he was somehow victim of the process, that he somehow is the underdog in all of this. And the best way to do that and overcome that, again, because he's so concerned with winning, is to manipulate a 13-year-old's emotions into feeling sorry for him. And that's everything he does. And then he has the audacity to attempt to file those as part of the public record, which again is a journal entry from his 13-year-old teenage daughter, which should be private thoughts shared only between the child and the counselor. My client tells you, that's sacred. She didn't even know about this journal. She didn't know anything about that until we get these text messages in which she's reaching out to Mr. Buag. Then we'll talk about the phone communications at the contempt hearing next month, talking about these issues. And then she finds out about this transition time. Around that same time, she gets a text message from Mr. Buaglio's father, who's a complete unrelated party to this, but part of the transition time, part of this journal group, that says and comments again, and we've provided you a copy of that, something along the lines, hanging around atheists is a scary place to hang out. He's referencing my client's new boyfriend. There, I said it. I am concerned for you and the girl's spiritual welfare. I question the wisdom that has you all in that place. You can block me if you want, but I'm praying that the Lord shines his light to send the darkness where it belongs. Unsolicited. This individual sent past text messages, which again were subject, it's history repeating itself again. Back 3 or 4 years ago, I don't know if it was your honor that heard that case or not, where we raised the same type of issue. They all then sit there around a table and talk about this journal with Danielle and put her in a position of saying, you know what, everybody around here who thinks like us, this is your circle, this is people you can trust. Everybody outside that circle is villainized, including the child's counselor, including my client, including the new boyfriend, and including 17-year-old McKenna. What does my client detail you about McKenna? McKenna, again, estranged from her father. That happened before the trial several years. Been very little contact. Mr. sees her at a sporting event or an extracurricular and treats her like a stranger. She attempts to go to a family holiday, and what's the reception she gets? You're not welcome here unless you sit in the inner circle and apologize publicly to me and my family and take accountability for your actions as a then 15-year-old child. Completely inappropriate. That gives you some context of what's happening with this situation. It's getting drastically worse. And 2 years ago, I never thought that was possible. We now have a 13-year-old who comes to my client's house, In addition to sequestering herself in her bedroom and going through dad's 31 lists of things to do that don't include your mom or sister, we've got the 13-year-old who's pulling her hair out. We've got a 13-year-old who is, again, prescribed what's called a Kankapin. I had no idea what that was until my client detailed it. It numbs her tongue when she breaks out with hives all over her body. This is happening more and more regularly. She's so stressed out that she took a pin and jabbed it in her forehead. This is not normal actions of a 13-year-old child. This is caused from something. The counselor, again, I think when a GAL can talk to the counselor, there's two currently. There's Charlotte Rosen for the family counseling aspect. There's Ms. Schmutz who's helping the child on a personal level. But we got dad who continues to infiltrate and try to sabotage all these efforts for his 13-year-old child. Because why? Because he wants to win. He wants to be put on the pedestal, and he wants this child to know that he's been the victim in this entire process. That is not right. That is disgusting, and he continues to do that and impact the mind of a 13-year-old child who is struggling significantly. He doesn't really make any apologies for it. He says, well, I'm concerned about what happens at mom's house. Why? He's not at mom's house. There's no emergent danger to the child. The child's seen a counselor. If there's any issues at mom's house, the counselor would call that in. The counselor would address it. He says that because of what he's putting in this 13-year-old child's brain, how he's manipulating this journal and transition time, whatever that is, and giving the child at 13 the positive reinforcement of, let's look at your journal. Well, I like that. That's good. It gives her positive reinforcement with it. And then turns around and tries to file it as a public record with this court action. Also asking not only not consider it, which on the hearsay grounds has already been established, I'm asking that you order that be stricken from the record at this point, or at least filed under seal, so that this child, when she is of age of 21 or 25, doesn't have to worry about her journal entries from being 13 revealed to the public because of what dad's coaching her at home. This is alienation. There's no other way around that. My client details for you the efforts she's gone through, the frustrations that she has, and her back is against the wall right now because the court made it clear to both of these parties, Mr. Buag specifically, you don't engage the child in this type of litigation, these types of adult issues. My client's trying to abide by that. She's telling the child very vague terms. She's trying to let the 13-year-old act like a 13-year-old, and dad is not. Dad tells her, well, this is a spiritual, Abigail is in a spiritual battle for her life. She's not. She's being put in the middle of chaos and nonsense because her dad can't get along with her mother, and unfortunately continues this battle and continues this cycle. And we're seeing it firsthand, the type of emotional response we get from the child. Court in prior hearings had made it abundantly clear that if this type of conduct was going to continue, there would be sanctions, there would be strict remedies, including reduced time in the parenting plan, including potential jail time. Dad hasn't taken any of that seriously. It took him 3 days to violate that. Dad continues to do it, and he takes zero accountability for it. Now, everything is pushed on to somebody else who, again, doesn't think like him spiritually. That's very problematic, and again, it's being impacted by the child. I don't know what the answer is, and I hate to come to court and say that I've struggled with that. My client has struggled with it. We've discussed options. I don't know what is a viable option at this point, but this child's being brainwashed and manipulated by dad at levels I've never seen before. I don't know if the option is just to eliminate visitation between now and when we get some kind of a GAL on board, and I would suggest probably an interim review is necessary. I don't know if we have the visits at reconnecting families or by an agreed or professional supervisor. I don't want to eliminate contact between the child and her dad. Abigail loves her dad. Abigail wants to have a relationship with her dad. Abigail holds her dad on the pedestal, right? Unfortunately, dad is using that as a weapon to try to, again, initiate this child in some kind of line of thinking that may or may not be beneficial to her. But he's certainly violating orders, and he's certainly violating common sense by having communications with the child that he's having. I don't know what the answer is with that, but I know what currently is happening is not working. I know that transition time is not beneficial for the child. I know that these network of Buag family members who, again, want to read journals and talk about spiritual warfare and battles and how mom is a villain and mom's boyfriend is an atheist, that's problematic. You are setting up and you are building a wall between the child and her natural relationship with her mother and everybody on her mother's side. And that is, again, I've used this word before, but it is disgusting. That needs to stop. I don't know how we do it. But that's kind of where we're at with this. I think we do definitely need to continue with the counseling. I think the child needs to continue with Janice Schmutz. Again, she's been with her for an extended period of time. And that was working very well, again, until dad takes active steps to try to impact that and negate the progress the child's been making. The family counseling with Charlotte Rosen is a great idea. Due to dad's actions, my client's the first to admit, I love my child. I've always loved my child. We've always had a great bond and relationship. Until about the last year or two. And what happens over the last year or two? We're in court. We have a parenting plan. Dad doesn't like the parenting plan. And here we are now, he's trying to create dramatics between mom and child. And again, it needs to stop. So I guess the suggestion would be, we limit his time pursuant to the prior orders, pursuant to the comments in the GAL recommendation from a few short years ago, from your honor's prior comments 3 years ago or so, from Judge Fassett's input at the time of trial in early May of 2022. Something needs to happen. This is not right. This is not helpful for the child, and it needs to change.
Response, and again, understanding that the contents of the journals are not to be spoken about.
Okay. Well, Your Honor, I just think it's very important to state that I have not violated the parenting plan. I take the parenting plan very, very seriously. I heard all of Mr. Zandy's concerns. Unfortunately, the majority of that was hearsay, and the only thing I can really say that was true in all of that was a text message from my father, which I had nothing to do with. And I actually, before even hearing about that from Ms. Buag, my father spoke to me about it. I said, please do not ever do that again. Jackie, that is not okay.
Yeah, I can.
So my main concern is Adiel's voice in all of this, and how much she is saying she is scared and she is petrified. She feels cornered. She hurts herself at her mom's. As far as the journal entries, I understand I can't reference them. I will just say that there are hundreds of them, and I only have Adiel 2 weekends a month. It'd be impossible for us to have that much control and all this that Mr. Zandy is claiming. It's just not true. Adiel is starting to speak up more and more to people outside of our families because she is scared and because she is hurting. And she said the pin stabbing incident in her forehead is because of the fear and anger toward her mother, not me. So all of this is being twisted substantially. And despite all of this, I have actually tried to help Adiel work on her relationship with her mother. I've supported counseling. We have nothing against counseling. I take her to appointments when necessary. I am a complete advocate for counseling. My wife is going back to school to get her counseling degree. Like, we are absolutely on board with Adiel's mental and emotional health. As far as the spiritual stuff, that was all really weird. I'm not sure where that's even coming from. Adiel has her own faith. She is very there are countless witnesses we could call upon for in the future of these proceedings to show that Adiel's faith is her own. I did not even read these journal entries until 2 weeks ago. I've never read in a journal entry from Adiel until 2 weeks ago when this was all filed. And I do not involve Adiel in court talk. I actually provided messages and evidence to show that that's actually coming from her mother. And Adiel's a smart girl. She sees court things in movies like the Santa Claus, where they throw the court paperwork in the fire. She's 13. She's smart. Her counselors say she's emotionally intelligent. She's a really smart girl. There's just a ton of conflict going on over at Ms. Buaglio's house that has to do with court talk. When Adiel comes over for transition times, as Mr. Zandy inaccurately described, that was a proponent from her counselor saying that, yeah, I think that's a great idea. Because what was happening is she was coming over here, and the whole time for the weekend, she would cry and bawl and say how she didn't want to go back to her mom's and she was scared of her mother. So we had a transition time to have her relax, decompress, get anything out in her journal that she needed to. And I never have once asked Adiel what is in her journal. I asked, hey, how are you doing? How was your week? Those are the only questions I ever ask her intentionally, so I do not violate court paperwork because I respect the court and the paperwork very much so. All it takes is for me to ask, hey, how are you doing? How was your week? And she breaks down and cries and shakes and says she doesn't want to go home and that nobody's listening to her. And her mom talks about professionals and all this stuff, and that she hates my family, and I don't understand why. Why does my mom hate my dad? And I try to encourage her. So there's a lot more going on here than Mr. Zandy is putting forth. And that is why I agreed that there is adequate cause, but not for the grounds that are being proponed. It's complete hearsay, and I haven't seen any evidence to the contrary that to show that any of what is saying is is true. If I ever walk Adiel out to a car, it's because she doesn't want to go back, and I'm walking her out there to encourage her. Mrs. Buaglio doesn't even knock on our door. She won't. Her shadow hasn't dawned our front step. I've reached out many times with my concern to Ms. Buaglio through text messages saying, Adiel is saying this. Is this true? Why are you doing this? You're hurting her. And to which we received no response. So that is why we've actually, since reading Adiel's journal entries 2 weeks ago, I was trying to figure out how to file an emergency order because she's claiming, that she feels uncomfortable around Ms. Buaglio's live-in boyfriend, that he gets...
I've let a lot be said that it's not in the record, and I'm not going to listen to the hearsay of the journals. I made that very clear.
Yes, Your Honor. Sorry, I was just trying to repeat Adiel's concerns because it's her voice I'm majorly concerned about, not my own. And Mr. Zandi has called me a martyr and all sorts of things. But we also have the text directly from Ms. Buaglio to Adiel that was very inappropriate, and I did provide that to the court just in case there was something wrong with the journal entries, because I'm not looking to violate anything there. As I said, I haven't read any entries until 2 weeks ago when the contempt paperwork was filed, and I figured I needed to dig a little deeper as to what was going on. I did not involve Adiel in court paperwork, but I respect her privacy, and I did ask, hey, if we ever need to read your journal entries and show anybody, would that be okay with you? And she said yes. So that was done with permission, not out of disrespect to her, the court, or anything like that. I just wanted to clarify that. I do not involve her in talk, but I did provide text from Ms. Buaglio to Adiel, and that alone should show some concern that there's a lot more going on here. I'm actually in fear for the safety of my child right now, and the fact that all this hearsay is being thrown out there like this is very concerning. It's Adiel's voice that I'm very concerned about, and I hope that the GAL will be able to talk to Adiel directly and get her story from her. I have nothing to do with her story. I advocate for her voice. I do not have some list I made. I don't even know what list he's talking about. Adiel is very into her mental and emotional health. We encourage her to play the guitar or do art or read books. She's read 12 books last semester outside of her Bible studies that she likes. She's an avid reader. We do not make her do things like that. We do have a very close relationship. And sorry, it's hard not to talk about the journal entries. But I did advocate the love between her and her mother, despite all these things going on. Because I know if this petition is gone through with as is, it will destroy the relationship between her and her mother. And despite all the false things being said about me, I do believe Adiel deep down still wants a relationship with her mother, and this would destroy that. She would hate her mom and never forgive her. I know that about Addie. So I just asked that the court wouldn't move forward with this temporary plan. It would be very harmful. There would be huge resentment, and it would damage things on so many levels. But I did agree to the adequate cause in hopes that a GAL will actually be able to hear Adiel's voice, and all this hearsay can be put to rest. As I stated earlier, the only thing remotely true is that I went out to a car with Adiel a couple times. Everything else about those statements were not true. I did not say and do those things. It was out of support for the child being scared to go back to Ms. Buaglio's house that I walked her out to the car. So I just hope that the GAL will hear the full story, and Adiel's voice will finally be heard and stop being silenced. It's very, very dangerous, and it's hard to watch because she has had substantial deterioration since the modification, because she used to be with us full time during the mental health crisis in March of 2020 with Ms. Buaglio, and she loved it here. And since then, everything has deteriorated. I do agree with that. The every other weekend has not been enough for her with this side of the family, and this side of the family is demonized on a regular basis. That there's things wrong with us and things Adiel just doesn't know, and that she's being protected. And so Adiel is speaking up. She is having a really hard time. She has a hard time watching the court stuff happen, and the court talk between her and her mother. And I have a hard time watching that happen and then being blamed for it, is what I'm trying to say. I would just hope that the court references the text message if they can't see the journals and see that there has, from Ms. Boiglio's own mouth, there has been inappropriate talk. And if I ask how Adiel is doing that week, or how you're doing, or how was your week, and she deteriorates into talk about her mother, that does put me in a precarious situation. That's why we're an advocate for counseling, that Adiel has somebody to speak to that isn't her parents. I can't speak to saying that anything about her being 13. She is 13. That is the law. I have not advocated her to stop speaking to a counselor. Quite the contrary. I ask that she have somebody to speak to where her voice is heard. That is the most important thing to me. I do not dictate her voice. I am not some weird martyr or villain or spiritual whatever, as Mr. Zandy says. It's all very awkward and strange. But I just ask that the main focus, Adiel did not do well with the major change. She continued to suffer. She is suffering, and it's a fight just to actually get her to go back and be around her mother again. It's very hard to watch, and some of the things in the journal entries are abusive.
Sir, you keep repeating what you've said.
Sorry, I'm nervous.
Okay, anything else?
No, I just asked that it not move forward today for very many reasons.
Counsel?
Three comments in the middle of that diatribe where he's talking about nothing but hearsay and saying he objects to the hearsay. He said some interesting things. He said, if we ever need to show anybody, he asked the child if he can look at that and show anybody. What does that imply? He also said that she's having a hard time watching the court stuff happen. This child shouldn't be watching any court stuff happen. This is the same individual who 3 years ago we provided a lot of information showing and confirming the fact that he was engaging this child in those very actions he's now, again, he's learned, trying to attribute to my client without anything to substantiate that. We advocate for her that she needs to tell people something where her voice is to be heard. Again, what does that imply to a 13-year-old? Would hate her mom and never forgive her if this were to proceed. Again, where does that originate? These are all thoughts that are put in her head by dad, and there's nothing in his presentation today that does anything to quench that issue related to what it is he's telling the child. And again, it's deplorable. So he can speak out of the one side of the mouth of, well, I'm not doing this. The problem is, again, with Jamie and Adiel. What's the root cause of that? The root cause is what dad's doing to her. And again, I think and I didn't bring past files with me because that would have been a lot to tote in here. But again, the record is complete on this. This is worse than it was back then, and it needs to change. It needs to stop. And again, I have no idea how we do that, but it needs to happen.
So I reviewed the files and record. I am familiar with this case, and quite frankly, that doesn't happen a lot. I hear hundreds and hundreds of cases, but when I recall and remember cases, that tells me a lot. That tells me I was struck by what was going on, the damage that was going on, the harm to the children that was going on, and the significance of that. Bottom line, I do not believe the father in this matter. I think there has and continues to be, whether it's understood, and that's what I don't know. If it's just not being comprehended or what, I don't know. So I too have been trying to figure out what is the best thing to do for the child and Adiel, and understanding the confusion that must be going on in her mind. First, I am going to have the journals entries of the minor child sealed from the public. So those need to go under seal. I'm not quite sure what you need on that, but okay. So we'll do an order sealing on the journals of Adiel. And then in regard to going forward, what I'm going to do is I'm not going to take a guardian ad litem off the list. I'm going to appoint Jennifer Schaefer to make an interim investigation and report to the court. And so that is a different court order than the regular guardian ad litem appointment. She's still a guardian ad litem. And but it's somebody who is prepared to do I guess, a quick response type scenario, so I know best what to do for a child. So what I'm going to do at this time is I am going to, do you have any idea from the counselor what is recommended at this point?
I don't. I know that the counselor is eager to speak with the GAL. I can confirm that. I think that we can, between Ms. Schmutz and Ms. Rosen, I think Ms. Schaefer could probably get to the bottom of that very quickly in one phone call, provided the waivers are signed as such. That's one of my concerns too, is everybody signs the waivers on the GAL order, allowing her to talk readily with the counselors. I haven't asked that. I've had limited information from her. I don't know the answer to that, but I know she is eager to talk.
All right, so what I'm going to do is, at this point, at least, is have supervised visitation between the father and Ariel. And that there's to be absolutely no conversation about the other parent that is disparaging, negative. There is to be no conversation about the court process and what's going on in regard to that. Anything that is to be told to Ariel will be come from Ms. Schaefer, who's properly trained in those areas. And so in regard to the visitations, bottom line is children want to love both parents. And I wish parents would get that figured out for when they are making negative comments about the other parent, that they want nothing more than to love both parents. So again, I want positive conversation no matter what. But in regard to the visitations, it'll be through a professional supervisor. I just don't know who's doing that here locally at this point. Mr. Zandy, do you know who's doing it?
Well, Reconnecting Families is still doing it. I don't know if Parents Place has any. I don't know if Parents Place is doing that, but I guess Reconnecting Families would be the start.
So we'll start with Reconnecting Families. And I didn't ask your input just because I'm assuming you're not familiar with what is available. But we'll start with Reconnecting Families. I'm looking at this to occur over a month's time. I'm not looking at this as a permanent change or something that's long-term. I just want to try to limit contact, at least for right now, with Ariel, until Ms. Schaefer has an opportunity to make an investigation and make a recommendation to the court about the father in particular, well, the visitation in general. I'll reserve, I was going to do a psychological evaluation with the parental risk assessment, but I'll wait and see if Ms. Schaefer thinks that that would be appropriate. The child will continue with counseling. For now, I'm not going to have the father participate in that counseling until the risk assessment has been done. So as far as the time, it's more about what can get set up with Reconnecting Families. At least, you know, if she can do a couple times a week for a couple of hours or an hour even, so you still have some contact with Ariel. That's what it'll be for now. It will be at father's expense. Anything else that either of you can think of?
No, do we want to turn around for April 2nd for presentation?
Presentation, April 2nd, that works. Does that work for you?
I believe so, Your Honor.
Okay, presentation for the order on April 2nd. Ms. Schaefer,
Yes, I'm here, Your Honor.
what are you thinking as far as how much time you need for an initial investigation?
If the counselors are open to speaking to me, I could probably definitely get things done in 4 weeks if he is able to have supervised visits so that I could then contact the supervised visit person and get their input as well.
Okay. All right, so let's go ahead and set this to April 23 at 9 a.m. for an interim review.
Very well, thank you.
All right, nothing further today. I'll hand this to you. First off, I see we have Ms. McLean,
Yes, Your Honor.
and looks like we have Ms., is it Swindell? You're muted.
Yeah, it's Swindell.
Okay. All right. So Ms. Swindell, the problem is that when I was looking at your documents, they're not sworn affidavits. And for me to consider them at all, they need to be sworn declarations, and they're not.
Okay.
So you understand that?
Yeah, I do. Is there a way I can make them sworn affidavits?
Well, you know, it's always difficult, like I have said many times, is I understand you're not an attorney, I understand you may not understand the rules, but you're held to the same standard of the rules. So let me hear from Ms. McLean in regard to that idea. Ms. McLean?
So my concern is that obviously we had Ms. Swindell appropriately served for this motion. Her responses were late regardless, and she didn't technically serve my office. She apparently had a copy delivered to my client, and I had been watching on Odyssey and observed that the documents had hit Odyssey. So that's how we became aware. Nonetheless, we've been able to put together reply documentation from my client. And given the concerns, we do believe it's appropriate to move forward.
Well, I am going to move forward today because there are significant issues and concerns. But you need to understand one thing, Ms. Swindell. First off, anything you file with the court, you must serve on Ms. McLean's office, meaning you provide a copy of it to Ms. McLean's office, okay? So that's one thing. Secondly, local rules have the timing of when motions are filed, the timing of when things are due. And if you don't do that, then the court likely isn't going to consider those documents. So even if you had sworn affidavits, then in regard to that idea, that they weren't timely. So you had two things in regard to those issues. Finally, I want you to understand this is a temporary order idea. This is not a final decision on anything. So I want you to understand that as well. Okay. All right. So Ms. McLean, with that, go ahead.
Thank you very much, Your Honor. So may it please the court, I do represent the respondent, Tucker Sundowne 8. And the court has already addressed the initial concerns as it related to the unsworn declarations. And I can tell the court when I was reviewing through Ms. Swindell's reply documentation, there are a number of text messages. I had difficulty understanding a time frame for many of those as they were not referenced in her declaration. The text, most of the texts themselves do not provide an actual date as to when these communications occurred. And at times it was difficult for me to understand who the communications were between. So I would just point that out and suggest that the court provide minimal to no weight as it relates to those text messages.
So I'm going to stop you for just a minute, Ms. McLean, on that. This is another thing I wanted to clarify, and I should have done it earlier. One, when people send in massive amounts of text messages, chances are we don't have time to even review all those text messages. And I don't remember how many pages there were of that, but 88 pages, I believe is what I have. We don't have time. But the other thing is that people often don't, one, give us dates. So I have no time frame. I have no time, no date, or who is even saying what. You may know when you copy it who's saying what, but I can't look at them and just go and know. So I want you to understand that as well. Okay, if you don't give any context to what's being talked about, there's nothing I can even figure out from it. So, and when I looked at the text messages, that was pretty much what I saw. Okay, all right, Ms. McLean.
Thank you very much, Your Honor. So these folks have an 11-year marriage and they separated about 2.5 years ago. They do have 3 children born as issue of their marriage. Jada is 11, Raiden is 13, and Jackson is 15. And as you can see from the documentation submitted by my client, these parties originally had filed for dissolution in Clark County. They were both residing in Clark County at that time. At that time, they had agreed to essentially a joint custody parenting plan with the children exchanging between each home on a week-on, week-off basis. Ultimately, that action in Clark County was dismissed for want of prosecution, and both parties have subsequently relocated to Cowlitz County. Most recently, Ms. Swindell has been influencing Jackson and encouraging him to stay with her primarily, even though the original parenting plan provided for a week-on, week-off provision. But as my client outlines in his declarations and documentation, there are significant concerns within the environment from Ms. Swindell. Jackson, obviously, at 15 is a teenager, and he is going to go to the location of least resistance, or at least in this case, the area of least rules. Unfortunately, Ms. Swindell has been involving Jackson in a litigation, encouraging him to stay. And even if you did have a chance to review some of the text messages, you'll see that there have been times when she has communicated with him while he's been at his dad's house and undermined Mr. Sandana's parenting authority during his residential time. On the other hand, Ms. Swindell also is of the opinion that if the kids are getting what she perceives as passable grades, then they're allowed to skip school, which is unacceptable to my client. And she has gone so far as to encourage Jackson to quit school, obtain his GED, and has discussed smoking marijuana with him. All of these things are concerns relative to her behavior, as well as her historical presentation. Clearly, Ms. Swindell has significant questionable judgment. We see that within her parenting of the children. We see that within her own current relationship, and we see that within factors that resulted in her losing her employment as a corrections officer. As my client tells you, and you see some of this in Ms. Swindell's responsive documentation, the parties were in a fairly drawn out hearing relative to ongoing harassment by Ms. Swindell and her significant other directed towards my client and his significant other. The concern is that Ms. Swindell is currently involved in a relationship with her former inmate with whom she had an inappropriate relationship with. They do have a child together. He also has a child from a prior relationship who has been engaging in inappropriately sexually charged behavior in front of or when the children are present at their home. And this is a matter that is currently being investigated by CPS from what I understand. My client has put in the request for CPS records, but as the court knows, that takes ages to get for a private citizen. And we're hopeful that a guardian ad litem would be able to cut some red tape as far as securing those records earlier. Ms. Swindell's significant other has a very violent history. He resides in the home. And as my client has told you, there have been instances where essentially he's been acting as the heavy on Ms. Swindell's behalf in order to force compliance by my client to her whims. My client tells you in response to Ms. Swindell's bald assertion that my client has been abusive, that in fact my client has been the victim. Ms. Swindell failed a Washington State Patrol onboarding employment polygraph because she was unable to answer that she had not been involved in domestic violence. My client tells you about her circumstances where she had pulled his hair, she had beat him, tells you about an incident early on in their marriage where she pulled a knife on him, also provides a police report from 2021 where she had threatened to kill him. Couple that with her own history of mental instability, and she acknowledges that she is not currently apparently on any prescribed medication. She's not currently in treatment with any type of a counselor. She identifies in her declaration that she utilizes marijuana to control her PTSD. The concerns are that marijuana is not appropriate for individuals with PTSD. It also can counteract her depression, which clearly has led previously to suicide attempts for her and hospitalizations. There's no way to meaningfully identify how much marijuana she's using to appropriately address PTSD. And again, that's contrary to medical recommendations. So at this juncture, we are very concerned by the environment within Ms. Swindell's household. Again, allowing the children to miss school, negatively impacting their performance. Ms. Swindell openly denigrates my client during text messages that involve the children, where she's calling him denigrating names, and as referring to my client's girlfriend in inappropriate terms. Unfortunately, even the children's medical issues have turned into a battlefield for Ms. Swindell, where she will cancel appointments and reschedule during her time. She will exert herself in an attempt to promote a false diagnosis or narratives. Even the sealed health documentation that she provides, which is from a well child check for Jackson in November of 2023, which I think is the child in the adolescent clinic, although it's not on letterhead, but I believe the location CAC Longview refers to child in the adolescent clinic, where even Jackson acknowledges mom is forcing him into counseling. We have none of the counseling records for the children, but clearly there are concerns as it relates to the children's environment with Ms. Swindell. We are asking that the court place all three children primarily with my client. We believe it's appropriate for there to be limited visitation. We're proposing first, third, and fifth Saturdays from 12 noon to 6 p.m. There should be a prohibition about Mr. Musso or his daughter being present during those visits. We're asking the court to restrain Ms. Swindell from using alcohol, legal or illegal substances unless prescribed by a physician, and that my client be allowed to ask for UAs, hair follicles, and the like standard provisions that are outlined in our proposed parenting plan with the loser paying. We are also asking the court to order Ms. Swindell to undergo a collateralized substance abuse evaluation and parental psychological evaluation with parental risk components. Obviously, it is concerning when an individual is somewhat excited about the opportunity to smoke marijuana with their children and is almost giddy about explaining that she was involved in a drug deal. Given her history, that's very concerning as far as what's going on within her household and her outlook as a parent. So we're asking the court to adopt the parenting plan that we've proposed. We do believe that it's appropriate for a guardian ad litem to be appointed in this matter. Given the relationship difficulties between the parties, my client is also asking for the entry of a restraining order. The proposed parenting plan provides for the exchange of the children at the Kelso Police Department, but we are asking for a restraining order that my client, or that Ms. Swindell not come to my client's home, workplace, school, etc., that she not disturb his peace and that she not threaten any type of assault or domestic violence. We believe that that's appropriate given the current status of this case. As it relates to financials, my client is employed as a supply planner with Ecolab. We have provided under seal documentation relative to his current wages and last year's wages. We're asking the court to set his net income at $5,785 per month. Ms. Swindell has not been forthcoming with regard to her income or assets. As we've indicated, Ms. Swindell has a family trust that apparently provides monies to her, as well as provides or has paid for her existing housing, which we understand she owns free and clear. She has a history of employment as a corrections officer, and it's our position that income should be imputed to her. For purposes of the child support calculations that have been submitted to the court, I've used the national median income for an individual her age, because as I sit here, I have no clue what her historical earnings have been. But obviously, as a corrections officer, that would have been significant. This basic child support calculation for the three children would be $951.90, We do recognize that Ms. Swindell has another child with Mr. Musso, so a deviated child support amount would provide for $796.86 per month. We're asking that the court adopt that effective March 1 of 24, and that Ms. Swindell pay her proportionate share of uninsured healthcare expenses and extracurricular activity expenses for the children. Finally, we are asking the court to allow my client to claim all 3 children as dependents on his 2023 tax return, as Ms. Swindell apparently does not currently have any taxable income. We believe it's appropriate for my client to claim all 3 children. Thank you.
Ms. McLean, you said from her declaration, what declaration are you referencing?
I'm referencing, so she did provide a cover page, and I just looked at the first and considered the first 3 pages of her declaration.
Okay.
So if you take a look at, for example,
right, and I apologize, Ms. Swindell,
okay.
it would be admissible.
I'm sorry, what?
So I want to clarify on what you filed with the court. The part that would be admissible that was talked about are the first 3 pages of the 88 pages that you filed. That's your letter. So anything that's in that you can talk about. Do you know what I'm talking about?
Yeah, sorry, I'm just trying to get my bearings. So first I want to talk about how inaccurate Mr. Sandana's document was then. He lied about multiple dates on his document. We did not get married in 2010. We got married in 2009 when I was 17. We also didn't separate in 2001. And I know I can't talk about it, but there's a police report. If we can extend this, I can get it sealed and put it in, of us even fighting in 2000, before the date even says when, sorry, I'm so flustered. He lies about when we separated. Also, I did not get fired from DOC. I quit. And yes, it wasn't necessarily to pursue a relationship, but I knew that my time in DOC had ended. The way that Larch Correction Center was ran, I did not agree with, so I quit. And yeah, I did meet somebody there, and we are together in a very healthy relationship. There has been nothing negative that's come from this relationship. I would also like to point out that Mr. Sandana says that Mr. Musso was used as a heavy. Mr. Sandana had no problem leaving our children with Mr. Musso while I was in the hospital for 11 days for visitations. They had no problems correlating that. He would leave our kids with me every morning on his visitations and every evening.
Lauren, some of this is outside of the scope of the declaration.
It's just the 3
Am I allowed to talk about his declaration?
Only if you responded in your declaration.
Okay.
I mean, if you agree with what he's saying, that's one thing. But if you're disputing it and you didn't dispute it in your declaration, then no.
Okay.
That makes sense.
I'm sorry. I'm trying to remember everything it was a lot in there. That was what was just in the first 3 pages. But there's been an escalation of behavior. It seems like every time if I play by the rules for Mr. Sandana, everything goes fine. We can co-parent just fine. And then as soon as my son doesn't want to get his hair cut and Mr. Sandana is forcing that on him, and I step in for my son and he's pushing these rules, and that's what I talk about in my declaration is an escalation in behavior. This happening. And now that I filed this with my son, my 15-year-old son, our 15-year-old son, asking to live primarily with me,
I guess I would object as to the hearsay.
I mean, there's a lot of hearsay.
I can figure it out. Just go ahead.
Okay.
I've never done any sort of drugs in my life. I am in active therapy. I see 2 different doctors. I just had a near-death experience last year, and so I'm definitely still healing from that. I'm I'm actively in therapy. I encourage my children to be actively in therapy. I don't go into their therapy sessions. My oldest, he's 15, they just butt heads. I'm not trying to like start this drama, but I do feel like when it comes to my kids, I do explode, and I'm trying not to, but when he's not letting me talk to my kid and I haven't talked to him for but there's never been any sort of like, there was when we first separated, there was the big, you know, explosion. Then he started dating, I was dating, we were good for like, and then now that things just aren't going his way, now he wants to, he's had people come to my house multiple times to sign, and that's in my declaration too, to come sign divorce papers multiple times. Nothing's been filed. Like, he has the money to do it. I don't have a trust fund that pays for my stuff. There is a trust fund, but we don't get anything from it because the park doesn't have any revenue. So if it sells, then yeah, I'll get some, but we don't have any revenue coming from that park. I haven't since like 2016. So I can provide proof of that. Like, I just need time. I don't know how to get all this stuff. I'm not an attorney. I'm sorry. And I feel like this is legal abuse. This is parental alienation because he's calling my kids into the room, talking to them about how dangerous I am, who all these dangerous people I hang out with. I'm building a business with my best friend since middle school. I smoke a little weed and that's it. And it's not even, CPS has come in because he's contacted CPS. He's had people contact CPS. They've come in, it's closed. I also provided that, but it's not, I can't talk about it.
Anything else?
I guess that's all I have to say.
Ms. McLean?
I don't think I have anything further.
So this is always difficult when one party is represented and the other is not. I understand your frustration, and quite honestly, the court gets frustrated with not knowing necessarily the full picture. I'm not saying that against the father. It's just one thing that I would note. And as I said, the same rules apply whether you're an attorney or not. The one thing there are organizations that you can make contact with, and so that's all I can say in regard to that.
I'm on a waiting list for one.
Okay. So, as I said, we are going to move forward. And so based on the admissible files and record, the court does order the following request of the father at this time. In regard to the proposed parenting plan. Let me go through that. I will adopt the 191 factors on paragraph A. On paragraph B, I will reserve. In regard to the limitations, visitation, at least at this time, will be the first, third, and fifth Saturday of each month from 12 noon to 6 p.m. Subject to the following. The father may request random observe urinalysis, hair follicle, or nail test of the mother at any time. The father shall prepay for the testing. All testing shall be observed by the testing agency. If the mother fails to provide the requested analysis testing within 4 hours of request, said failure shall be considered a positive test, and all visitation shall be suspended pending further court order. If the mother submits to testing and said testing shows positive for illegal or non-prescribed drugs, including marijuana or alcohol, or as validity concerns, the mother's visitation shall be immediately suspended pending further court order. Failure to submit to testing a positive test result for drugs or alcohol as outlined above, or test results where validity is questioned, shall require the mother to reimburse the testing costs to the requesting parent within 7 days of the testing date. If the analysis testing is negative, the requesting party shall bear the cost of the testing. Copies of all the urinalysis testing results shall be provided to both the requesting parent and the parent tested. The mother shall be enjoined or restrained from talking negatively or allowing third parties to talk negatively about the father to the children. The mother shall provide their current address and phone number at all times prior to their visitation. The mother shall be enjoined or restrained from being under the influence or consuming alcohol, legal or illegal drugs, except as prescribed by a treating provider. The mother shall be enjoined and restrained from allowing the minor children to have contact with Jason Musso and or Kiana Musso or any known domestic abuser, drug user, any individual under the influence of alcohol or drugs. In regard to evaluations, the mother must be evaluated for and receive the following substance abuse evaluation. I am not going to order the psychological evaluation with parental risk components at this time. That will be reserved. The evaluation shall consider input from the other parent and the guardian ad litem. Evaluation shall be completed with providers agreed upon between the parties and are approved by the court. All evaluations and participation in any recommended treatment shall be at Ashley Swindell's expense. The mother shall start or continue and comply with treatment as recommended by the evaluation. The mother shall provide a copy of the evaluation and compliance reports to the other parent and the guardian ad litem within 5 days of receipt of the same and to the court and all parties under seal. If this parent does not follow the evaluation or treatment requirements above, then 1, failure of the mother to provide evaluations as recommended by the guardian ad litem shall be cause for the father to have visitation issues to the mother reviewed by the court. The court shall maintain jurisdiction to ensure compliance and or enforcement of this provision. As to decision-making at this time, it will lie with the father. And they are listed out in the parenting plan. I'm not going to read through everything. Dispute resolution shall be by the court. Excuse me. In regard to parenting time, I've already talked about that. Transportation, the children will be exchanged for parenting time at Kelso Police Department parking lot. Each parent should pick up and or deliver the children to the exchange location identified above, being the Kelso Police Department. The children shall transport themselves from each parent's vehicle to the other parent's vehicle. So in other words, I do not want disputes and fights and arguments at the Kelso Police Department parking lot. The children shall be picked up and returned at the designated times. Should a delay become necessary, the other parent shall be notified immediately. All transporters shall be timely in their transportation exchanges of the minor children to avoid delay of more than 15 minutes following the time of exchange. If there is an emergency, that information shall be relayed as reasonably as possible to the other parent. If the parents transport the children by automobile, then age-appropriate children's safety restraints shall be used at all times during said transportation. B, only licensed and insured drivers may transport the minor children. Failure of the parent transporting the children to provide proof of insurance result in a waiver of visitation until such time as appropriate documentary proof is provided. I'm not going to go through the moving with children. That's all in there. If either party moves, what that takes. And then paragraph 14, it just talks about education, information regarding the children, the exchange of that information, the communication with children. And I want both parents to make sure to read that and follow it. So with that, I'm signing off on the parenting plan. So Ms. Swindell, in regard to the parenting plan, I know you don't agree with it. I just need to know if you approve via Zoom.
I'm sorry, what?
So your signature is not on the parenting plan. And I know the signature does not mean that you approve of it necessarily. It's just whether or not I can put approve via Zoom because it's what I'm ordering.
So I have to say I approve it?
It's up to you.
No, I don't approve it.
Okay. In regard to the restraining order, I'm signing off on that restraining order. Ms. McLean, will you be getting copies of these things to Ms. Swindell?
Yes, I will, Your Honor. Would you please, on page, excuse me, page 2, paragraph 4.
I
Mark.
marked it.
Okay, and then also on page 3, paragraph 7, ask that the court indicate not required since we already previously served it and it's similar. That I will provide conformed copies of all documents to Ms. Swindell.
So Ms. Swindell, in regard to this, I have to ask you the same thing. Do you approve the assume? It doesn't mean you agree with it. It's just that it conforms to what I'm ordering.
Yeah, that's fine.
So I'm just putting approved. The assume again, that's not to say that you agree with it. It's just that it reflects what I'm ordering. Understanding that, Ms. Swindell, do you want me to change what I put on the other one?
Yeah, please.
Okay. All right, and then in regard to child support, the court is adopting the child support worksheets, imputing at the median income based on the work history with the commencement of March 1.
Your Honor, I haven't worked since December of last year. I was hospitalized and I've been at home taking care of my kids since then. I don't know what you want me to pay child support with.
Basically, I'm finding that you're voluntarily unemployed and that you have the ability to be working full time. I have nothing to show me any differently. So it starts, I'm going to make as April 1, not March 1. So it doesn't go back in time if that's what you're thinking.
So did the court make that change at paragraph 11?
I will. But in regard to the child support worksheets, are you okay to again understanding what I'm ordering? Not that you're approving it, to put approved via Zoom.
Yeah.
And then I'm going to appoint a guardian ad litem. Who do we have next on the list?
That is Sherry Evald, Beth Bellows, Karen Lawrence.
McLean, do you strike any of those?
I don't think I have any objections.
So, Ms. Swindell, basically you have a right to object to any 3 of these if you so choose. I know you're probably not familiar with them, but it's up to you.
Yeah, it doesn't matter to me.
Okay, so we go with the next one on the list, which is Sherry, is it Evald?
Evald.
And is it SH?
SHERI.
So this one, I'm actually going to need a different order. Ms. McLean, under the application from Ms. Swindell, it states that she's indigent. That was upon filing of this matter. And so that would mean I need to make her half payable by the county.
Is the court willing to just interlineate that on the top of page 4 under petitioner, that would be county pay? Her 50% would be county pay?
Problem is that the amounts are different.
Oh, okay. So how do we handle that? which threshold do we use Let me go back to, I don't remember off the top of my head what the new amount is for county. Okay, so
What
the
I've seen is
50%,
that the 3,300 is for the one paying
right?
private pay, and the 1,485 is half of that is what's.
So why don't you do 1,650 instead of 15% for the respondent, and then 742.50 would be for the petitioner, $742.50, and then maybe just reference that that's county pay. And then,
Hold on. So Ms. Swindell, are you there?
Yeah.
So in regard to the guardian ad litem, I determined based on the indigency for the filing that your half would be paid by the county and the respondent's half would be paid by him. So that's what those figures are all about.
Okay.
And they go at different rates, county pay versus private pay, and that's why the two different figures are being talked about.
Okay.
Okay. All right.
and then does the court want to add a reservation language for review of reimbursement once we get further discovery?
All right, I did put review of county paying petitioner's half is reserved for further review once income is known.
Okay. And could I inquire if Ms. Swindell has an email that she can share for that form as well for the GAL to reach out to her?
It's Ashley.
Thank
So
you.
Ms. Swindell, on our Cowlitz County Superior Court website, there's a page for the guardian ad litems. And go to that page and you can look for Sherry Eval's name and contact information. And you can let her know that she was appointed as the guardian ad litem in your domestic case. Okay, do you know what a guardian ad litem is?
No, I don't.
Okay, guardian ad litem is somebody appointed by the court to investigate the best interest of the children and make a recommendation to the court as to what they see, as I said, the best interest of the children for visitation and schedule and that kind of thing.
Okay. I understand to a certain point, but how are they gonna know if they don't ever see the children in my care? Or will they?
Well, work that out with the guardian ad litem.
Okay.
Okay.
All right.
So they're trained. They know what they need to do. They know what they need to ask you for.
Okay.
Okay. All right. All right. So I have signed off on that order.
And then you should have a temporary order.
Okay. And then the email I'll just put in here, Ashley, Swindell. All right, so I've signed off on that. That brings me to the temporary order, and all the temporary order really does is, there are some additional orders that I did not talk about. The petitioner will possess and use vehicles, financial accounts, and personal property in their possession now, including but not limited to the 2020 Chrysler 300 and 2005 Dodge Durango. And then the respondent will possess and use vehicles, financial accounts, and personal property in their possession now, including but not limited to the 2018 Ram Rebel 1500 and 2021 Yamaha R7. Both parties must not move, take, hide, damage, borrow, against, sell, or try to sell or get rid of any property unless it is a usual business practice or to pay for basic needs. Both spouses must notify the other about any expenses that are out of the ordinary. The petitioner and respondent must each be responsible for their own future debts, including debt from credit cards, loans, security, interest, and mortgages, unless ordered differently. And then the respondent at this point, Tucker Sandana, shall be allowed to claim as exemptions and or tax credits for the tax year 2023. The petitioner, Ashley Swindell, shall complete, sign, and mail to Tucker Sandana IRS Form 8332 release or revocation of release, a claim to exemption for child by custodial parent for the tax year 2023 as to all 3 children. Ashley Swindell shall mail the completed IRS form 8332 to Tucker Sandana within 14 days from entry of this order with the court. Okay, that form I believe can be found online. I'm not quite sure. But that form you do need to get signed off and mailed to him.
And if Ms. Swindell has no objection, I can also email that to her, and we can arrange for her to electronically sign it if she would prefer.
Yeah, that's fine.
Okay, we'll get that done.
Thanks.
Are you okay if we email you conformed copies of the orders, or do you want me to mail them to you?
Email's fine.
Okay, all right, thank you very much.
All right, and I'll just approve via Zoom. Are you okay with that?
Yeah, that's fine.
And just for the clerk's edification, the GAL appointment order sets a 30-day compliance on the GAL process of April 30th at 9 a.m.
You know,
And then,
that's fine, I guess. That's spring conference.
oh, I didn't know that.
I don't know what dockets they're gonna have.
So could we set that then to May 7?
That would be fine. Let me get that back. Ms. Swindell, what I'm talking about is the judges go to a training for a few days, and so we don't have our regular dockets. So I'm going to change the date of April 30th to May 7th. So Ms. Swindell, your next court date is going to be May 7
Okay.
at 9 a.m.
And then that also sets a final GAL review on August 6th at 9 a.m.
Okay. All right, so those are 2 important dates to remember. But Ms. McLean will get you a copy of everything. So make sure to review it and read it carefully. Again, understand these are temporary orders. These are not final orders. And make sure to make contact with the guardian ad litem.
Yes, ma'am. Do you know when our next court hearing, will there be a chance for this to be changed, the parenting plan?
I will look at the report if the report is done and possibly consider it. Just depends on what the content is.
Okay. And then also I know it said something about a UA and there being no marijuana in it. I have smoked marijuana, so it's going to be in there if I go to like take it today or in the next 30-45 days.
Yeah, that's understood.
Okay. So they're not going to just like not let me see my kids if it's in there a little bit, right?
Ms. McLean?
What's your last day of use?
Today.
Okay.
Fine.
All right. I'll discuss that with my client. We'll take that into consideration. Obviously, that's on the record as well.
Yeah. Okay.
All right.
Okay, thank you.
Thank you. That takes care of everything for today.